I woke up to diesel engines, not birds, not wind in the pines. Diesel, it was barely 6, that gray hour when the light hasn't decided what it wants to be. I stepped onto my back porch and saw them. 2 bulldozers, a grader, and 3 pickups idling along the tree line behind my fence. 14 acres of hardwood and brush. My grandfather bought that land in 1958 with money he saved laying rail. Orange construction fencing snapped in the breeze. Concrete stakes were already hammered into the soil. Survey flags marked clean lines through woods I used to hunt as a boy. A sign near the access road read, "Future site of Hawthorne Ridge, 96 luxury homes." I walked down to the iron property marker I set myself 20 years ago. It was gone. Yanked clean out. One of the operators looked at me like I was in the way. I didn't shout. Didn't call the sheriff. I just said, mostly to myself, "They're building on land they don't own." Then I turned around, went back inside, and unlocked the fireproof safe. I spent 30 years walking property lines most people never think about. Rain, heat, ticks, courthouse basements. I worked as a county surveyor long enough to know one thing for certain. Lines matter, inches matter, paper matters. I'm a widower now. House is quiet. Coffee tastes the same every morning. My place sits just outside the subdivision line because it was here first, long before the HOA, long before the glossy mailers promising executive living. I never joined, never had to. My grandfather cleared those 14 acres with a chainsaw and a mule. I learned to track deer back there before I could drive. Every tree feels familiar. Inside my office, I keep bound plats from the 1950s, tax receipts in labeled envelopes, survey overlays I drafted myself. I don't trust memory, I trust documentation. I've always said it the same way. Land doesn't forget, paper doesn't lie. To the HOA board, I'm just the old guy behind the fence. Quiet, stubborn, out of step. They've got developers, attorneys, bank financing. I've got a file cabinet, and I know exactly what's in it. Daniel Kerr liked cameras. Could see it in the way he stood, chin slightly lifted, sleeves tailored just tight enough to show he didn't miss the gym. Former commercial developer. Spoke in phrases like community enhancement and unlocking value. Hawthorne Ridge was his newest expansion play. They'd already rezoned the old farmland east of me. County approved it in record time. Pre-sales were strong. Young families signing contracts for homes that didn't exist yet. Their position was simple. According to their filings, my 14 acres had been inadvertently excluded from updated subdivision plats in the early 80s. An administrative oversight. They called it implied common development land. They backed it with a glossy digital plat map pulled from the county's online system. I'd worked on that system. I knew what got lost when records were digitized. Behind closed doors, I later learned Kerr called me a paperwork relic. A week after the bulldozers arrived, a certified letter showed up. Case interference. Trespass warning. Legal action if I obstructed development. I didn't respond. Instead, I drove down to the county records office and asked for the original books. That's when the real pressure started building. They didn't slow down. Within 3 weeks, concrete trucks were lining the access road before sunrise. Slabs went in. Framing followed. The smell of cut lumber drifted across my fence like it belonged there. For sale signs turned into under contract banners. Then the letters started coming. First, a property tax adjustment showing my acreage reduced by 14 acres. Just like that, as if land could evaporate. Next, a survey revision filing attached to the subdivision expansion. Then a formal notice from the HOA attorney accusing me of harassing contractors, simply because I'd walked the boundary line. Neighbors who used to wave stopped making eye contact. Someone posted online that I was anti-growth and trying to tank property values. I didn't argue. I hired an independent title researcher out of Charleston. Quiet woman. 30 years in archival work. 2 days later, she called about a 1946 rail easement buried in the original deed chain. She said, "You're going to want to see this yourself." I didn't tell anyone what we found. At the planning office, officials insisted there was no recorded dispute. But I noticed something buried in public filings. The construction loan required clean title certification. That was the first real crack, and I knew exactly where to press. The archive room smelled like dust and cold paper, temperature controlled. Lights low. The clerk wheeled out a gray cart, stacked with bound volumes tied to a 1946 rail land swap that predated the subdivision by decades. I put on cotton gloves and turned pages older than my father. There it was, my grandfather's deed, original parchment, full meets and bounds description running clean through the 14 acres now scraped flat for foundations. Bearings, distances, iron markers noted by hand. In 1983, when the county digitized records, one page of that legal description never made it into the system. A clerical omission. The online plat everyone was relying on was incomplete. I traced the chain forward. No deed, no conveyance, no transfer out. And in the margin, written in fountain pen, a note referencing a reversionary clause upon improper subdivision. I closed the book slowly. A week later, I sat across from a quiet real estate litigator downtown. He studied copies without much expression. "If this holds," he said, "you don't just own it. Every structure could be trespass, possibly unjust enrichment." Then he looked at me. "Why didn't you stop them earlier?" I told him the truth. Because now it's measurable. By late summer, it looked like a neighborhood. Sod rolled out in tight green strips. Irrigation systems clicked at dusk. Model homes were staged with farmhouse tables and lemon-scented candles. Could hear kids riding bikes through streets that technically didn't exist yet. 80% complete. That's when I filed a formal notice of adverse claim with the county recorder. I didn't ask for an injunction, didn't try to halt construction. People later ask why. Because every nail they drove made it measurable. The development loan finalized in draws. Each phase required certification that title was clear. Buyers were closing under warranty representations that the land was properly conveyed. The deeper they went, the greater the exposure. That handwritten reversionary clause wasn't decorative. It triggered land reclamation rights upon unauthorized subdivision, and compensation tied to improvement value. They weren't just building houses, they were compounding liability. I documented everything. Drone footage with timestamps, recorded planning meetings, copies of loan filings pulled from public records. Meanwhile, Daniel Kerr stood at a podium during a local press event and called Hawthorne Ridge a smooth expansion of community vision. I watched it online without expression. 3 weeks later, instead of backing down, the HOA made its move. They sued me. They filed first. Quiet title action. Boundary by acquiescence. A claim that I'd knowingly allowed development for months and was now interfering for leverage. They even asked for damages tied to project disruption. Local media picked it up fast. One headline called me a holdout landowner threatening 96 families. I didn't give interviews. In pretrial discovery, my attorney submitted certified archival copies of the original deed chain, along with layered survey overlays drafted by an independent expert. Transparent sheets showing historic bearings overlaid against the HOA's digital plat. The differences weren't subtle. Opposing counsel waved it off in filings, calling the old deed superseded by subsequent subdivision mapping. That word stuck with me. Superseded. Court date was set for early November. The night before our evidentiary exchange deadline, I unlocked the fireproof box again. Beneath the working copies sat the original 1958 deed. Thick paper, blue embossed county seal. My grandfather's name in ink that had bled slightly into the fibers. I hadn't shown that version to anyone, not even my attorney. Paper doesn't lie. The next morning, we walked into court, and for the first time, Daniel Kerr looked unsure. The courtroom smelled faintly of old carpet and copier toner. Fluorescent lights hummed overhead. Stacks of binders lined both tables. Behind me, I could hear low murmurs. Homebuyers, a couple reporters, 2 men in suits I recognized from the lending bank. The HOA's attorney went first. Clean slides. enlarged digital plats pulled from the county website, smooth presentation about administrative intent and community continuity. Then my attorney stood. He laid transparent survey overlays across a mounted board, historic bearings in red, modern subdivision lines in blue. The misalignment was precise, uncomfortable, and then he asked the clerk to mark Defendant's Exhibit 12, the original 1958 deed, thick parchment, blue embossed seal catching the light. Could feel the shift in the room. A certified land records historian testified next. Calm voice, no drama. In 1983, during digitization, one page of the legal description was omitted. The meets and bounds extension, through the disputed acreage, was not carried forward. There is no recorded record transferring 14 acres from Mr. Ellison's chain of title. He paused. The reversionary clause activates automatically upon unauthorized subdivision. The judge leaned forward, expression tightening. I saw one of the bank officers whisper to another. Title insurance exposure had just become real. When the full survey comparison was displayed, there wasn't ambiguity. All 96 homes sat inside my boundary. Daniel Kerr stopped taking notes. For the first time, he looked like a man who'd miscalculated. And that's when the consequences started moving beyond that room. The ruling came 2 weeks later, concise, direct. I retained clear title to the 14 acres. The existing structures were deemed encroachments. The court ordered both parties into formal damages mediation and noted the activated reversionary clause on record. That single line shifted everything. Within days, the title insurer intervened. The construction lender issued a notice of default tied to defective title warranties. Funding froze. Closing stalled. Realtors stopped returning calls. At the next HOA meeting, attendance overflowed into the hallway. Homeowners demanded answers. An internal vote forced Daniel Kerr to resign pending review. He never spoke to me again. Mediation lasted 3 long sessions. In the end, we reached terms. I agreed to a retroactive land sale at a premium value reflecting fully improved lots. The HOA covered every dollar of my legal fees. Governance restructuring became mandatory. Independent audits, stricter disclosure rules, limits on board authority. The county quietly opened an inquiry into how digital emissions were accepted without verification. It wasn't explosive. It was procedural, systemic, and it was enough. But once the numbers were finalized and the wire hit my account, I had a decision to make: money or principle. I could pushed harder, forced buybacks, demanded teardown threats, let the pressure roll downhill onto families who had nothing to do with bad paperwork and worse decisions. But most of those homeowners bought in good faith. They trusted a system that was supposed to protect them, so I made different demands. Every home would carry a small surcharge, paid into a community land trust dedicated to preserving green space permanently. The remaining woodland bordering my house would be placed under a recorded conservation easement. No future expansions, no creative reinterpretations. The restructured HOA would require independent financial audits and transparent voting procedures written into its bylaws. And from my portion of the settlement, I funded a scholarship at the local technical college for surveying and land management students. If lines were going to matter, someone needed to know how to read them. One evening, I walked the restored boundary and drove the original iron marker back into the soil. I pressed it down with my boot and said it quietly. Land doesn't forget. Paper doesn't lie. Then I looked up at the houses beyond the trees, and I thought about you. Here's what I learned. Digitized records are convenient. They are not infallible. One missing page in 1983 almost cost me 14 acres and handed 96 families a legal nightmare. HOAs speak with confidence. They rely on polished language and the assumption that most people won't challenge paperwork once concrete is poured. Authority, when repeated enough, starts to sound like ownership, but strategy beats outrage. If I'd rushed in swinging the first morning those bulldozers arrived, I would looked emotional. Instead, I let the numbers grow. I let the liability mature. I made it measurable. So I'll ask you something straight. Would you have stopped construction immediately or waited? Tell me what you would have done. And if you've dealt with an HOA that crossed a line, I want to hear that too. Next week, I'm sharing the story of a homeowner who uncovered an HOA president funneling fines into a private account. But before you assume your boundaries are safe, when was the last time you read your original deed?